the December 15th, 2020 Wolfeboro Planning Board meeting. My name is Kathy Barnard. I'm the chairman of the Planning Board, and this meeting is being held in person and virtually. Some members are appearing virtually, and some of us are here in the Great Hall. The first thing I'm going to do is call the roll. Peter Goodwin. Here. Brad Harriman.
I'm here also.
Okay, Von Dugan.
Here.
Okay, and I'm supposed to ask the three of you if anyone is in the room with you. Sorry, I neglected to do that.
No.
No.
Okay, Brad.
No.
Oh, okay, thank you very much. Okay, we'll continue. These folks are present in the Great Hall. Susan Replier.
Here.
Mike Hodder.
Present in person.
John Thurston.
Here.
Julie Jacobs.
Here.
And Kathy Barnard. I'm also present. Also here is Tavis Austin, the planning director, and Mary Jane Shelton, who's taking the minutes. You folks at home, can you hear all right?
I can.
Yes.
Okay.
Yes.
Okay, that is very good news. All right, then I'm going to call the meeting to order. And what we have on the agenda tonight are the public hearings for the proposed zoning changes that we're proposing to have on the town warrant in 2021. The first ones that we're going to go through, the hearings were opened at the last meeting on December 1st and continued until this evening due to some technical issues. So we did discuss the amendment to the Shorefront Residential District, which is the first proposed zoning change. This is 175-67. But just let me briefly go over this one due to the issue that people are having a hard time hearing at the last meeting. So these amendments are simply to make the Shorefront Residential District zoning regulations clearer and easier to interpret for the public and for the staff members. They have been put forward by the former planning director. And basically, the reason that we're making some changes is in order to encourage more people to consider water quality when they're doing construction in the Shorefront Residential District. So many of them have to do with addressing stormwater management issues. We did have one suggested change, which I mentioned at the last meeting, and that was from Roger Murray. He felt that the wording was too loose in 175-67A1C. We did discuss this at the last meeting, and the planning board members decided that they wanted to stay with the existing wording, that they felt that sufficiently dealt with the issue. Am I correct in that? It seems to me that was what everyone
That's correct,
felt.
Madam Chairman.
That there was no change necessary. There was another issue. Vaughn, you were concerned about the non-conforming structures in 25%, the ability to expand by 25%. That provision in the zoning ordinance is not at all affected by the changes to the Shorefront Residential District. So I'll go ahead and open the public hearing on this item. Is there any member of the public that wanted to comment? Yes, go ahead, Tavis, sorry.
No, that's fine. One other change that was discussed in the same paragraph you were referring to in 175-67A-1C. There are certain instances in the shorefront residential where a certificate of occupancy doesn't apply, but a certificate of compliance does, such as the addition of a deck. And I would just suggest that it is not a substantive change, but a clarification that if the final sentence in that 175-67-1C were to end in by the town prior to the issuance of a certificate of occupancy / completion.
Madam Chairman, last time we unanimously approved the change to read issuance of a certificate of compliance / occupancy.
Oh, okay,
That's
Is
fine.
that the same thing?
Yeah, that's the same
That
thing.
we-
Yep.
we all agreed
We
on
just
that
didn't bring it up tonight, so I wanted to make sure it was still there.
yes, okay. And Tavis, I had also asked you to take a look at these amendments to make sure that you were comfortable with the changes. I mean, I know you weren't here when they were developed, but since you're now here, you'll have to implement them. And so in this particular case, are you comfortable with the changes?
I am comfortable with the changes, and I believe they'll make it easier for both the public and staff to be able to have a dialogue in processing the applications.
Okay, thank you. Okay, and I don't hear any member of the public wanting to comment on this. Planning board members, I would entertain a motion to
So moved.
to move this on to the town warrant in 2021.
So moved, Madam Chairman.
Okay, motion has been made. And,
Oh, wait, are we allowed to discuss this?
yes, I just asked. Yes, I just asked if anyone had any questions.
Okay, sorry, it's a little fuzzy.
Okay.
But my basic question is about the word "and" in section lot redevelopment. Section 2, there's a long statement about greater conformity. And the word "and" is an issue, and I think still that it competes with the idea that you can expand something 25% in the setback. That's another part of the regulation we'll be working on later. But if it says "and," you have to reduce the nonconformity, but in another section, we're saying you can expand 25%. I don't think the word "and" is right. I think it's still should be "or."
Where is she?
Where are you, Vaughn, please?
I am on, so it is section D, lot redevelopment. Number 2.
Could you give us the number?
Number 2, D2.
I mean, 175, what, 67?
Yes, 175-67.
D?
D is in David. 2.
2, thank you.
Okay, D, I thought you said that, okay.
Okay.
It's like 4 pages.
Oh, okay, would you make your change again that you're concerned about, Vaughn?
My concern is the word "and." If you also have to reduce the nonconformity, but by the same token, you could allow 25% expansion, and, do stormwater management, which I think is the point of this whole exercise. We're trying to increase stormwater management.
Yes,
I just find if you have to reduce the nonconformity, but later on you're allowed to expand it by 25%, that's confusing.
So what would clear it up? How would you rather it be phrased?
I think you could say "or." I think if you have to reduce the nonconformity, then what we're going to discuss as an amendment to the zoning later doesn't really justify with this.
I don't read it that way, Vaughn. I read the sentence to say the following, that there are ways of achieving greater conformity. They include 1, reducing overall square footage, / reducing nonconformity, and enhancing stormwater management. That's number 2. It's not an either or. It's not a requirement that the two be conjoined. It's a sequence of items, the and joining the second to the first. That's how I read it.
So I read it as something that you have to do both of, and to me implies both,
Okay,
not or.
Well, the way that the stormwater management reads, the and aspect of just to get to 25% is a very piddly stormwater rain garden. It's barely anything. So the threshold is very low there, and then you get into more restrictive after you get up over the 25%. You have to get an engineer's report to create the stormwater management system. So the first threshold is very minimal, and that's what that refers to. Am I not mistaken?
Yeah, and it's simply a recitation of the ways in which you can achieve greater conformity, but not limited to only that number. That's how I read it.
go ahead, Tim.
Madam Chairman, I would agree. I read it very similarly. I think the only thing I would add if I were the author would be a comma after legally nonconforming structures, comma, and. Because it says methods for achieving greater conformity include, without limitation, comma, you could say 1, reducing the overall square footage of the structural footprints, comma, 2, reducing the nonconformity of existing legally nonconforming structures, comma, and 3, enhancing stormwater management. So it's a series of things that one could do.
I think adding the comma, like Tavis suggested, solves that problem, at least as far as I'm concerned.
I think so too, but when a non-conforming structure is expanded by 25%, isn't that a special exception?
Well, you can expand up to 25%. Going over 25% is the special exception, but I think the criteria is how are you going to balance this all together? Because going back to the meeting at the last discussion, well, you can increase by 25%, but at no point can you achieve 30% lot coverage. So there's going to be the balancing act on what you cover and what you treat. So I think by putting the comma in, you address all of those parameters.
Yeah, but so in the layman's terms, though, when an applicant comes to you, the first threshold, up to 25%, is a, person-to-person situation. Once you go past that, then you're into the waiver, which brings you also to a certified stormwater management system.
Correct.
And that's how those relate together.
Correct.
So I'd be happy to propose the addition of the comma after the word structures in that section, and that not being a substantive change would not require a second public hearing on this
Okay.
article.
Okay. Vaughn, are you comfortable with that?
As long as it reads that you don't have to do all of the above. Yeah, I don't want it to exclude the fact that you can add 25% to a building and then do some stormwater management and satisfy this.
You've heard the planner's verdict on that, and he would be the individual looking at this ordinance as it applies to a particular project. So I think if the planner is in agreement with the board, I think we're fine.
Okay. Okay, any other comments? Mike had made a motion,
I'd second that.
and John seconded the motion. So the motion is to move this proposed amendments with the 2 minor changes to the town warrant. I'll do a roll call vote. Peter Goodwin,
Yes.
Brad Harriman,
Yes.
Von Dugan,
No,
Susan Replier,
Yes.
Mike Hodder,
Yes?
John Thurston,
Yes.
and Kathy Barnard. I vote in favor of the amendment. Okay, thank you. The next one is the...
Can I make a statement at this time? in that it's seems as if the audio is doing very well, and so I commend the people who are associated with that.
Thank you.
Okay, all right, very good. Thanks for saying that, Peter. Okay, the next amendment is to the design guidelines standards, and Mike is going to speak to this one.
Okay, this is a pretty simple one. This is a housekeeping measure. It brings the town zoning ordinances up to date by removing existing references to, quote, voluntary design review guidelines, unquote, and replacing them with references to, quote, architectural design standards, close quote. It's a change in terminology only. The background to this is as follows. On February 18 of this year, the Planning Board held a public hearing to discuss repealing the existing design review guidelines in the town's site plan review regulations, section 173-19, parentheses, cap B, close parentheses, and replacing them with the architectural design standards the Planning Board had crafted through the work a subcommittee commissioned for that purpose had done. Following the public hearing, the Planning Board adopted the new architectural design standards as section 173-19, cap B, close parentheses, of the town's site plan review regulations. That adoption required changes in terminology throughout portions of the town zoning ordinance. Those changes are as follows. In 175-155, parentheses, cap B, close parens, 175-106, note 2, 175-107, note 2, 175-116, note 2, 175-117, note 2, and finally 175-121.4, parens, cap F, close parens. And that is essentially the presentation, Madam Chairman.
Okay, thank you. Okay.
Any questions?
Okay, and I'll open the public hearing on these amendment changes. Any member of the public want to comment? Okay, planning board members, do you have any questions or comments?
Happy to move this to the warrant, Madam Chairman.
Okay, thank you. Motion has been made to move this to the 2021 town warrant. Would you like to second that motion?
Seconded.
Second, okay. Motion has been made and seconded. I'll do a roll call vote. Peter Goodwin?
Yes.
Brad Harriman?
Yes.
Von Dugan?
Yes.
Susan Replier?
Yes.
Mike Hodder?
Yes.
John Thurston?
Yes?
And Kathy Barnard, I'll vote yes. So that, those amendments now pass on to the town warrant. Mike, do you want to, the next one is the non-conforming structure.
Sure, that's a pretty simple one also. This is a minor change to clarify the meaning of the text, and it simply eliminates what's confusing and repetitive language. It inserts the word, quote, lawfully, unquote, between the words, quote, existing, unquote, and, quote, non-conforming footprint, close quote, and removes the text that now reads, quote, of the existing, comma, lawful portion, close quotes, from the ordinance. The effect is to underline that the 25% maximum allowed expansion and extension of a non-conforming structure is to be based on its lawful footprint. The change updates the revision of 175-43, which was approved by the voters in March of '29, and the change in terminology affects the following zoning ordinance: 175-43, cap A, parens 4, close parens. And I will read the language as it is to be proposed. 175-43, non-conforming uses. A, expansion and extension. parens, paragraph 4, close parens, the basis for determining the maximum and cumulative expansion limitations, close parentheses, open parentheses, 25%, close parens, shall be the existing lawfully non-conforming footprint, parentheses, measured to the overhang extent, close parentheses, of the non-conforming structure, comma, excluding appurtenant features such as exterior stairs and non-habitable areas such as open decks, period, close quote. That's it, Madam Chairman.
All right, thank you. I'll open the public hearing on this proposed language change to non-conforming structures. Does any member of the public have any comment? Okay, planning board members, do you have any questions or comments at this point?
No.
Okay.
Be happy, Madam Chairman, to move this change also to the 2021 warrant.
All right. Motion has been made.
Seconded.
And seconded. I'll do another roll call vote. Peter Goodwin.
Yes.
Brad Harriman.
Yes.
Von Dugan.
Yes.
Susan Replier.
Yes.
Mike Hodder.
Yes.
John Thurston.
Yes.
And Kathy Barnard. I vote in favor of the proposed change. The next one is for Habitable Space. And this is one that was proposed by Matt Sullivan. We've discussed it. I'll read it. Habitable space, a space in a building suitable for living, sleeping, eating, or cooking. Closets, halls, storage, or utility spaces in similar areas are not considered habitable space. Half baths located on the ground floor only in an accessory structure shall not be considered habitable space. Hallways, breezeways, open and enclosed tunnels, and the like shall not be considered habitable for the purposes of connecting two or more habitable space areas. This was proposed, the planning board has discussed it. However, when our new code officer came on board, he took a look at it and he said that he didn't feel as if we needed that. That really it was consistent with the building code. And, Tavis, maybe you want to comment on that.
Thank you. For edification of the board, bathrooms are not considered living space by building code right now. So half bath, full bath is not considered habitable space. So the code officer's position, and I tend to agree with him, is that by adding this sentence to the definition, it's becoming more confusing than it needs to be. And that by leaving the reference to half baths on the ground floor out, the definition remains more consistent and enforceable by building code. To that end, if you think of other examples, such as I'll say a split-level garage, there is no definition of ground floor. So is it the level that is closest to grade, or is it closest to grade that you exit upon at ground level? So it becomes very tricky. I understand, I think, where the language is coming from. It's attempted to prevent full baths in accessory structures that would potentially lead to rental units or other such uses of those structures. But I would strongly caution the board to going down this path towards affecting something else you're trying to regulate. So to that end, if you understand that bathrooms are not considered habitable space, then adding this in here is a bit superfluous.
Well, so this is a little history on this item, actually.
Okay, there is a second part. But go ahead.
Well, I'm trying to understand what sentence are you trying to craft?
I'm not trying to craft a sentence. I'm recommending the board not add the sentence that says, quote, half baths located on the ground floor only in an accessory structure, shall not be considered habitable space, period.
Okay, but let me add that what we're trying to achieve is to allow half baths in accessory structures.
That's right, from the history that
Yeah.
started this whole ball
Yes,
rolling.
right.
Because as I remember, it was Mr. Montrone that wanted to have a bathroom in his garage because the old ordinance didn't allow for plumbing or anything in a accessory structure on your property. So the initial thought was to add the ability for somebody to have a bathroom in their garage so they didn't have to run back and forth to the house and the garage.
Okay.
Then what happened is you got people who were building a garage, then they put a bathroom upstairs, then they took all the kitchen stuff out of the house that they just tore down, then they made the upstairs into a living area, and when the codes officer goes there, he doesn't have any arrows in his quiver to do anything, he just has to turn and walk out of the building because he knows he can't do anything.
Okay, so what the proposal is to not move ahead with the proposed language for habitable space. Instead, and again, this was discussions with our new code officer. He suggested adding some wording to the definition of accessory building or structure. And we would simply add to that, accessory building or structure shall be limited to a single half bath located on the ground floor, which is the situation that John just described. And that's what has been allowed over the years and what we want to continue to allow, or that's the proposal, to continue to allow people to have a half bath in the first floor of a garage or an accessory structure. So this new wording for accessory building was not advertised at the same time as our other zoning amendments, but it has been properly advertised now.
Correct.
So that's why it's a new addition at this point in time.
Yeah, and we will be dealing with that as the last item on our agenda of proposed zoning changes tonight. So we're passing over the originally intended change for habitable space because we're not going to make any change, but we are changing accessory dwelling structure to incorporate the change that we feel is necessary.
Yes.
Based on advice.
Right, so is everybody clear? And is there any member of the public that wanted to comment on the habitable space definition? And planning board members, are you clear as to the reason why we would like to withdraw this proposed amendment for habitable space, in that it's really not needed?
I'm not.
Well, but we're going to then add.
I don't understand what the plan is. You haven't, I mean, we could, don't understand what's going forward here. So,
okay.
because I don't have it in front of me and I can't look at it, so I don't know what's going on.
Okay. We're talking about withdrawing this wording and adding this wording.
Thank you,
To
Dennis.
accessory structure. And the reason that we're suggesting withdrawing it is because it's really not necessary.
So does it still allow people to build their second level over their garage?
Yes,
Well, I'd be,
People can still have
well, I'm not
two
for
or
that,
three
'cause
floor
that's
level
what-
garages.
We need to stop that right now, because that's what's going on, and people are abusing the system out there. And
But the bathroom
they're
spaces-
creating an unfair advantage to other people who are following the rules, and then these other people aren't following the rules, and they're getting away with it, and we can't do anything about it.
I'm not understanding what they're getting away with and having an unfair advantage with.
the advantage is for somebody to take a house down, take all their kitchen stuff, build their garage first, then they build their shower, they build their bathroom, they take their kitchen stuff and they put it in their garage on the second floor, and now they have a second living situation on the same lot. So it's two dwellings on the same lot, basically. And the other people that are following the rules are saying, okay, in this one, you said you can't have tunnels. Basically, it's trying to get one dwelling on a lot. And if we take this away, we've taken that check away, which is going to allow people to manipulate the process.
In most zones, you're only allowed one dwelling on a property unless you have an accessory dwelling unit.
But people are building kitchens and living situations over the tops of their garage without permission, and the town can't do anything about it enforcement-wise.
Well, if they're building it without permission, I'm suggesting you mean that means they don't have a building permit, which is against the law, and they're not allowed to create a separate living unit unless it's an accessory dwelling unit. So there are laws that prevent separate living units on properties without any change to the definition of habitable space.
Which is why he suggested.
It just requires a building permit.
Correct.
Is that correct?
Already covered.
I mean, to that end, there's nothing in the zoning ordinance that precludes you from having 5 kitchens in your single-family home.
So what was the matter with our former planner and the codes officer that he was having here when they couldn't enforce it? Because I know exactly of a situation that they're talking about.
Did they not require a building permit? I mean,
They had a building permit to build the garage, and they hooked the sewer line to the legitimate sewer because they had the size of a sewer system that would plentifully hold that bathroom, and then the bathroom morphed into a bathroom and a shower, then it morphed into a living situation. A full bedroom with a kitchen.
Okay, so what the ordinance prevents is a separate family from living in it.
It was a in-laws, it was basically kids, in-laws, and children.
So kids, in-laws, and families all still the same family by definition.
No,
Well, I mean, technically, if it's all family, it's all family.
But it's a
not
second
separate
dwelling, it's now a second dwelling on a lot.
right.
Okay, but I don't understand how preventing somebody, because if you look at it the other way, putting a bathroom in a garage is not creating a unit.
What we're trying to do is the idea of putting the bathroom on the lower level and not calling it habitable basically said that this accessory garage was just an accessory garage with no habitable area, but we're allowing you to put a bathroom on the first floor.
Right, and that's.
I understand what you're saying as a board, but it becomes very difficult to enforce what you were suggesting. What is, I mean, very simply, what is the difference between a half bath on the second floor or the first floor?
Because we don't want half baths on the second floor because it creates a living situation.
Turn into habitable space.
That's correct.
What is the ground floor?
Ground floor is where you pull in your vehicle, and that's...
Okay, that's not defined in the ordinance. There is no definition of the phrase ground floor. So if you're building on the side of a hill and you have a garage that you can walk out of without going up or down stairs on the ground floor by your definition or second floor, where is the code officer allowed to have a half bath installed?
We could say the lowest level.
Thank you, Vaughn.
I think we're getting carried away here. The issue before us is the proposed, or not even actually right now before us, the issue before us is whether to leave the existing language of habitable space as it stands now. Later on, we're going to be looking at the issue of accessory dwelling space, and whether that's habitable or not. If we have a problem with the definition of habitable space, that's something we should put on our work program for 2021 and thrash it out, not tonight at a public hearing, on an issue, do we keep the old ordinance or not? The alternative to not keeping the old ordinance is what? To rewrite it tonight? We can't do that.
No, but I hate going forward and doing work where we hash it over 4 to 6 times, and then we come to the meeting here and we yank it off the table. I don't understand why we put all the work in if we were so sure, and then we got to this point, and now we're gonna retract it.
Because we've been offered advice from 2 professionals that the change is not going to accomplish what we wanted it to accomplish. And if there is an issue with the definition of habitable space, it needs some thought and some input from the code enforcement officer and the new planner.
Right,
And we lose, I'm sorry, Kathy, go ahead.
No, go ahead.
I'm sorry, I didn't mean to interrupt you. I just wanted to add that Matt was the one that asked the new code officer to look at this. And so Matt was still here when this was transpiring. And so he said, yes, that made sense. As long as we added the half bath to the accessory structure, so that that's clear. You can have a half bath on the lower floor of an accessory structure. But I think Mike is right, that I think we need to talk about the issue and get Steve, the code officer, in here so that he can explain what he's seeing out in the field and get some suggestions from him, because it is a problem, John. I'm not denying that at all. And I think we really need to look at it.
My
Because
suggestion,
we're seeing more and more of these accessory structures, these dwelling units.
yeah, my suggestion is that John has identified a problem, and a problem that needs a solution. I don't think that tonight, in this particular forum, is the place to find that solution. I think we need time, work, and some professional advice to get that done. But it's a problem that perhaps wasn't as identified as it is now, you know, and thanks to John for bringing it up. But I think we need to move on,
Okay.
pass over the change originally planned for habitable space, get that locked away, and then put that change on the work program for 2021.
Right. Are you comfortable with that, John?
Well, I'd like to get a reassurance from the planner that he's got a plan that he can address the issues when a guy goes out there to see something and he sees what's going on, and then you walk out of there and you just shake your head knowing what's going on.
Right.
What I'm trying to say, John, is that the building code definition of habitable space does not count bathrooms right now. So by adding half baths located on the ground floor only in the accessory structure shall not be considered habitable space begs the question. They're already not considered habitable space. It's not considered living space. A bathroom in your house, in your garage, in your whatever is not considered habitable space. So adding it in here is redundant at best in the definition of habitable space, because building code does not consider a bathroom habitable space.
That was a justification for not going forward with the change, that it really is redundant. Habitable space doesn't include a bathroom. So adding the language that it doesn't include a bathroom kind of says the same thing twice.
Okay.
The other issue here is perhaps instead of working on the definition of habitable space to work on the bathroom and the living quarters issue, we should really put that in the definition of accessory structures. Maybe they're limited to half baths and not, we forget about the habitable space crossover.
Agreed.
Oh, okay, well, that is what is being proposed.
Mm-hmm.
Yeah, we'll deal with that later on.
When we get to that one.
Okay.
So, Madam Chair, if the board is willing to not make the change to habitable space because it was advertised. I would suggest a motion to,
Yeah, well, that's,
okay,
Pass over.
to not move forward with it.
so, John, are you comfortable if we make a motion to withdraw this from consideration this year if we put it as a priority on the work program?
Yeah.
Okay,
I'll second that motion.
okay, a motion to withdraw.
Correct, to pass over.
Proposed language in habitable space. Motion has been made and seconded, and I'll do a roll call vote. Peter Goodwin?
Yes.
Okay, Brad Harriman?
Yes.
Von Dugan?
Yes,
Susan Replier?
Yes?
Mike Hodder?
Yes,
John Thurston?
Yes.
And Kathy Barnard, I vote in favor of withdrawing this from consideration. I think we got to remember that we started with one,
I know.
you know, and we changed, and so
it's the most,
that's okay, we'll get there, not to worry.
that I think, Madam Chairman, was the most complicated piece of work that I've done in the last couple of months, trying to keep that straight. All the changes that we had to habitable space and accessory dwelling units.
Yes, right. Okay.
More so than parking.
All right, so on to the next amendments, and this is off-street parking and loading. And Mike is going to go through this one.
Okay, thank you, Madam Chairman. While the copy of this article is presented for public hearing tonight may appear complicated and impenetrable, the changes to the parking regulations the Planning Board proposes are actually pretty simple and will be easy to follow. For the people at home and those who are not in the room tonight, in your copy of the proposed changes, the changes are indicated in red. The underlinings are new text. The strikeouts are deletions from the existing text. 5 sections of this article remain unchanged. Sections 175-129 and 175-134 through 175-137. 4 other sections need some light editing and/or corrections. Sections 175-128, 175-132, and 175-133, and 175-139. Edits and corrections in 175-128 include 4 deletions of text no longer necessary. In 175-132, a change is needed to make the section work when other sections are incorporated into site plan review regulations. In 175-133, paragraph F requires additional text to make clear what it intends. And in 175-139, the land use names have been rearranged into logical categories and other uses have been added. All that will be needed is to renumber those sections to account for the changes. 3 sections of this article will be moved to site plan review regulations, where the Planning Board has the authorization to work with town officials and applicants to craft parking management plans that can flexibly accommodate both public requirements and private aspirations. Section 175-130 establishes parking regulations for 2 districts not previously included: Wolfeboro Falls Limited Business District and Bay Street Limited Business District, areas that are seeing growth and new needs for parking. Section 175-131 will be joined with Section 175-138 to allow for the creation of flexible parking management plans by applicants with creative solutions to problems of limited off-street parking and zoning requirements. That's essentially all I have to provide here. I can answer questions as they arise.
Okay, let me open the public hearing. So I'm going to open the public hearing for the off-street parking and loading. there any member of the public that wants to comment on any of the proposed changes? Okay, planning board members, any questions or comments? We probably should add that our town attorney has looked at this.
Yeah, the town attorney has looked over this at the previous planner's request. Her concerns were addressed by Matt, previous planner, and there are no issues remaining that need her consideration further. That's all I have on that, Madam Chairman.
Okay. All right. So questions or comments? This parking ordinance was redone, gosh, I think it was back in 2011. It was back quite a while ago, and we had a committee that looked at it, and we tried to make it a little more flexible. But like anything else, when you go back to take a closer look at things, you realize that in some cases you've created some conflicts and things that aren't very clear. So that's Mike and Matt and I had, at the board's request, sat down and went through this whole ordinance in order to clarify some things, and we wanted to give flexibility for what we call the greater downtown area, which is why we added Bay Street, Limited District, and Wolfeboro Falls. So we think that what we're proposing is going to work better for the planning board. As Mike said, some of the issues are going to be in site plan regulations, which will give us some flexibility.
We began this work, Chairwoman Barnard and I and Matt, back in November of 2019. That's the first note I have on my copy. And we worked, the three of us, through the summer and then presented it to the planning board, and the planning board reviewed it at least twice before. There were a number of areas in the ordinance as it exists now, before we move it to warrant, or at least until before the town votes on the changes, that simply didn't make any sense. There were a couple of places in the ordinance where the language was contradictory. There was one part of the ordinance which called for the establishment of a trust, which was never set up. The parking fees, which were never set up. The ordinance in many respects was unenforceable because it was not carefully crafted. The important part of the change, moving the parking management plans and the shared parking plans together into site plan review, allows the planning board, when applicants come before it with a proposal that requires parking, to come up with creative solutions that the current ordinance doesn't allow for. The current ordinance, for example, says that parking management plans should adhere to the intent of the master plan. Well, it's hard in a zoning ordinance to enforce the intent of the master plan, because what part of the master plan is being referred to and what is meant by intent. In site plan review regulations, the planning board has the flexibility to understand what the intent of the master plan is by looking at the community facilities chapter, for example, and seeing what it has to say about parking and where that is applicable. Zoning language should be hard, clear, and precise, and applicable to all applications. But suggesting that a parking management plan comply with the intent of a master plan is such a wide open requirement that it's really hard to enforce and would essentially be inapplicable. So we made some changes, put portions into site plan review, and I think we've crafted an ordinance that will allow creative solutions to parking management plans that don't exist currently, and also allow them to exist in 2 districts where they're not currently allowed at all. Thank you, Madam Chairman.
Thank you. Any other comments? Okay, then I entertain a motion to move this to the town hall.
So moved.
Okay, thank you. Or do you want to second this?
I'll second it.
Okay.
Thank you, John.
Motion has been made and seconded. Do a roll call vote. Peter Goodwin?
Yes.
Brad Harriman?
Yes.
Von Dugan?
Yes.
Susan Replier?
Yes.
Mike Hodder?
Yes.
John Thurston?
Yes.
Kathy Barnard, I vote yes. Okay, so now we're back to, to deal with the last amendment, and this is to accessory building or structure. And we've already had a bit of discussion about that. As I indicated, this item had to be advertised separately, and so that time and the legal notice has been properly done as of tonight's meeting. So that's why this is the first time that you're seeing this. And this is to sort of address the concern that John had about making certain that accessory buildings or structures could have a half bath on the ground floor. And so that's, those are the words. Again, this was suggested by the code officer after we had a discussion with him about the habitable space. And he said if that's the concern, that this brief wording should address the issue. So all we're doing is adding to the existing definition of accessory building or structure shall be limited to a single half bath located on the ground floor. And this would be a convenience thing for people in detached garages and detached accessory structures so that they could have a toilet and sink. So that's the explanation, and I'll open the public hearing for this item. Any member of the public want to comment on this? Planning board members. John, are you relatively?
I can see the intent here, so it's at least got something in there that's got meat on the bone.
Okay. And doesn't beat around the bush?
No?
Right, okay. All right. Any other comments or questions?
Well, my recollection of this is associated with how somebody who wanted to have a workshop or a whatever in an accessory building wouldn't have to run back to the house to use the bathroom. And so I believe that it seems very reasonable.
Okay, thank you, Peter. That's exactly the intent. Okay, somebody be willing to make a motion to have this proposed amendment on the town warrant for 2021?
So moved.
Peter, so moved.
I'll second it.
Okay, motion has been made and seconded. I'll do a roll call vote. Peter Goodwin?
Yes.
Brad Harriman?
Yes.
Von Dugan?
Yes.
Susan Replier?
Yes.
Mike Hodder?
Yes.
And John Thurston?
Yes.
Kathy Barnard, I'll vote yes. Okay. All right, very good, folks. So we're all set with these, and you make
So we
those
have to do
minor...
one more meeting with that? Yep.
No.
We're all
No,
done.
we don't.
We don't? It's just a wording?
Yes. Right. Yeah,
I didn't hear the question.
this was, he wanted to know if we needed another meeting, but
On accessory dwelling?
Right.
Yeah.
No, you're only required one public hearing.
It's only one.
Right. Yeah, I mean, really what we did was take some wording out of one and put it into
Okay.
the, okay. Okay, doesn't seem to be any member of the public to make any public comments, or I don't believe there's a member of the public. No, I don't see anyone. Okay, under other business, discussion of drive-through restaurants. I had a,
Non-conforming structures?
we did that one. That one was kind of quick.
Yeah.
I had another email from Mr. Zimmerman wanting to know if we had received and commented yet on the email that he sent around Thanksgiving time, November 17th. As far as this issue is concerned, the last discussion that we had before hearing from Mr. Zimmerman was that I think it was most of the planning board felt that we should have a public meeting to get input from members of the public regarding this issue.
Mm-hmm.
And so, and what are your thoughts as far as the email from Mr. Zimmerman? I told him that I'd get back in touch with him. And how do you want to proceed with this? I mean, there's, I don't know if he's wants something on the 2021 warrant, but that, I mean, certainly
Madam Chairwoman,
to achieve that.
his memo says, the final paragraph, quote, "I would like to encourage the planning board to put a warrant article on the ballot. I assume that means 2021. Asking voters if they support the drive-through restaurants, and add a note that the planning board does support that warrant article." The planning board is already on record a number of times having concerns about drive-through restaurants. We currently have a definition which excludes drive-through restaurants from the town. I think it would be premature of us to put a warrant article in favor of drive-through restaurants with a planning board recommendation on the 2021 ballot without any kind of study whatsoever, and we haven't really done that. I would suggest that we stick with our original intent, put a public forum on the subject onto the work program for 2021 and do it early. Mm-hmm. And get the issue thrashed out. These are sorts of things that we have to think about are, what districts in the town do we want, or would we think a drive-through restaurant would be most appropriately located? What's the lot size likely to be? Local traffic impact, parking? How do we deal with issues of franchise architecture and site plan review, because people in town have strong feelings on that? The impact on the town utilities. I would like to get opinions from town officials, including the Board of Selectmen and stakeholders in the town, in particular current restaurant holders, how they would feel about this issue. And then once we have all that kind of information, present it in a public forum and see what the town wants to do.
Okay, so you're saying do the study first and then have the public forum, or?
I think we ought to go to the public with some knowledge rather than simply say, what do you guys think? Because then we're asking them to do our work for us.
Okay.
Julie's got a question.
Yeah, go ahead, Julie, sorry.
I'm still just wondering why we're going to do all that studying when on the 2020 ballot, it was, we voted as a town, no. So it kind of seems pretty quick off the start here to, ooh, the next year, let's do it again. I'm not sure who it's benefiting.
Well, this is how I see it, Julie. It's been before the town on the ballot twice. It's been struck down twice. In both cases, the vote was 2-1 against. But there's that 1-4. You know, there's a chunk of the town which would like to see a drive-through restaurant here. Mr. Zimmerman makes points in his memo, I think a little bit dramatically, but there are genuine points there. A guy on his way out of town at 4:35 in the morning might benefit from a quick stop through, get a hamburger or whatever on the way down. So I wouldn't want to disenfranchise, so to speak, 1/3 of the town, or 1/2 of the town, really, without some kind of study. And the study isn't going to cost us much, except a little bit of time and some work, and then get the input from the town and let the town people tell us what they think. And if it's overwhelmingly no, then clearly, you know, everyone will have had their day in court. We will all have had a chance to be heard, and we can put it on the shelf until the next time around.
Yeah, it just seems like we just did that, though, you know, with the whole voting thing, that's all.
What was that?
It just seems like, to me, like we just did that when we voted. We just voted that's the way that we felt, rather than now getting into more studying.
Well,
I'm just seeing that the more that it's stirred and stirred and stirred, that people give up. People are like, oh, I'm just going to vote for it. I'm sick of voting no.
Oh.
That's what eventually happens when the squeaky wheel keeps, you know, turning it over, is what is the way I'm feeling at this point. That's just me off to the side.
No issue that's political is going to stay quiet forever. Sooner or later, you know, things necessarily change, and I really feel, I mean, personally, I'm not entirely happy with the idea, but that's just me personally, not as a planning board member, just me personally. But I can't forget the fact that a good chunk of the town voted for this. And to simply say, well, you know, you had your chance, you lost it, issue's closed, you know, take a hike, is kind of hard when to look at it. And we've never really looked at like traffic studies, parking studies, opinions from other departments in town, stakeholders. We've never had the stakeholders here to hear what they have to say.
I think that's the important one that needs to be listened to.
Like we did with the hotel owners a couple of years back. You know, absent that kind of information, it's hard to justify a recommendation against in any terms other than, well, the zoning doesn't allow it.
Oh, and also our own zoning ordinance is inconsistent in some people's minds because we allow drive-through banks, and if a drugstore or some other retail establishment wanted to have a drive-through, they would be allowed. So I think that issue should be addressed.
I think we may need a new word here too, because you say drive-through for the bank, drive-through for the restaurant. And to my mind, those are two separate things. When, you know what I mean? When you say franchise restaurant, I go, oh, that has a drive-through. You know what I mean? It just, when you use the word drive-through in those two separate things, they mean to me two totally different things. So I would say it's a drive-through restaurant. That just to me is like, that's the accessory Dunkin' Donuts that you can't walk into. That's the little kiosk, you know, I drive up to Aroma Joe's. That's what that means to me. You know, so I'm feeling that we're going to have some word issues going into it.
Yeah, well, there's an issue of, you know, the population is getting older. Certainly we've seen people, you know, picking up food during this last year, and so maybe it is something that we should relook at. Go ahead, John.
So, recognizing how we got here, this was a petition warrant article twice with many townspeople signing on to that petition warrant article. Then Mr. Zimmerman came to us. He said, geez, you guys, when you vote against my article, it doesn't do my article any good because the townspeople get basis from the planning board, then they don't vote for it. So we as a board hashed that over one night, and I thought we came up with a discussion and a resolution that we weren't going to make a recommendation on the article if Mr. Zimmerman put the article in front of us this year to go on the warrant article as whatever he was going to sell it for. He needs to sell his own proposition to the people, the way I see it. The planning board isn't going to sell his drive-through. The things that will sell his drive-through are the pandemic and takeout this year, because nobody's doing dine-in. We made special exceptions on Railroad Ave for Bailey's Bubble to have parking spots, to increase their area. We've done it to many other places. We did outside dining down here in many locations, allowed them to take up parking spots. We know that through 2021, we're still not safe. People aren't going to be going indoors. They prefer to do the takeout and have the fresh air, and I think it's a big deal. I think we're being a little aloof here by not helping the situation out a little bit. The way I understood it, we were going to try to get a forum where we were going to have a discussion. I didn't hear anything about a study at any of our discussion meetings, and so that's kind of new to me. I hate to do legwork and tie myself up knowing that the person that wants it is trying to proposition the town to accept it. That I don't think it's our job to do all the study. I'd like to hear from the people, absolutely. But to do the study and all that stuff, I'd like to leave it to the person who would like to do the project. And as far as franchise architecture, we just overcome that hurdle by our architectural design guidelines. We basically have guided the applicant into a situation where we are going to be able to recognize the facility for what it is, but our guidelines are going to give us the security that we are looking for to represent our people. So in one sense, I think it's Mr. Zimmerman's prerogative to put it forward. If we said we were going to take a position on the way we voted for it, I think we ought to live up to our word and do what we said what we were going to do that day.
We never said that, John.
I don't recall ever saying we wouldn't opine.
Never.
I'm sure that we always do.
Never. We never said that we would not put any kind of a tag, yes or no, on Mr. Zimmerman's article should he present it for 2021. The issue is moot anyway because the deadline for petition warrant articles from the public has come and gone, so we haven't seen it as far as I know. Okay. So it's not going to be on the 2021 warrant. As far as studies are concerned, I wasn't suggesting a study that was going to cost a dime. It's the kind of studying that you can do. I'd be happy to do it personally at no expense to anybody, just for the fun of it, just to learn a little bit more. What I do not want is to run a forum and say to the public, come on in and tell us what you want, and have absolutely no knowledge about the issue whatsoever to talk to them about. So, you know, that's where I stand. Yes, it was his warrant article. Yes, he was going to profit had it passed because the number of lots that were qualified for a drive-through restaurant in his article were limited, and a number of them were his. So it's fine. You know, he can do that if he wants to. No problem whatsoever. I'm not trying to do his work for him. I'm trying to do my planning board responsibilities for me so that when someone comes before me with a presentation like he might make, I can say, but what about the traffic? And know what the answer is going to be before he says it, because I've already done my homework.
So what I'm feeling from you, Mike, is that you want to kind of like do this little job anyways.
I'm sorry, I can't hear you
What
very
I'm
well.
feeling is that you want to do the little job anyways of figuring this whole thing out, not just for this one particular person.
No, just for me in general, I mean,
That's fine.
it's something
fine.
that
It's
we
just-
need to do.
I didn't want to get in, you know, on this little ship over here and say, oh, it's all for here. That's just,
I have no dog in this fight. Only the town's interests. Is a drive-through restaurant a good idea for the town?
so is there any
Don't know.
reason that we should rush it? You said to put it on the work session
There
quickly?
is no way that it can go on the 2020.
No, I meant, he said 2021
Right.
quickly, he said.
Well, I'd like to work on
2021.
it on the work session, if that's the case.
2021 work session, yes.
Anytime.
The earliest this could come up would be 2022 now. So there's no rush. And I'm not suggesting that there ever was.
Right,
Okay.
yeah.
I'd like to add one
Let's listen to Vaughn.
additional comment, and that is that, you know, this pandemic has brought a lot of the current restaurants to curbside delivery. I mean, people can come in, pick up food, and I think we should make a big effort to support our current restaurants that are making an effort to stay alive by delivering food at the curb or you can run in and get the food. So I think that there's food available. I don't think that that's a reasonable argument, actually. And I think we ought to support the people who have been in this town for a long time and are trying hard, you know, to survive the pandemic.
I also don't think that time-wise, which is always used, you said 4:30 in the morning to leave. We have a restaurant that's open at 5. The minute that the people are there, the door is open. You might have to wait until 4:45 for the grill to warm up, but they're there. You can get food. So I don't think that has anything to do with it.
I'm not arguing the particulars, because I don't know the particulars. That particular was in Zimmerman's letter. I don't know if it's true. I know Katie's is open at 5 to catch the guys heading out of town in the trucks to go, you know, for the job sites. Clearly, there's a need. Zimmerman
there is.
identified it as well. I don't know whether it would be better satisfied by Katie's plus something else, or just Katie's. I don't know. None, you know, we haven't done the work. As far as supporting current restaurants that are doing curbside deliveries, here, Vaughn. Never suggested otherwise.
Yeah, no, I agree with Vaughn too, but we're not in the business to throw a dart at a dartboard and say this is the business that we should support and we
Right.
should support all businesses. Whatever somebody wants to bring forth, if it's a viable option, then we should try to support it. I'm sorry. And we'll listen to the people to say if they think that's a good idea.
Right, we are the town's planning board. We are not our own entity.
Could maybe we think also of what Vaughn just said too? Everybody's trying to do curbside pickup. Has that been allowed before?
Yes, the governor's special
Yeah, I know.
executive order
I
allowed that.
mean, right now, but I mean, once that all ends and everything goes back to whatever, is that really kind of like still allowed from these restaurants still? Was there anything that maybe we should, you know, at the same time as we're looking at the quote drive-through things, look at those as well?
It's a different issue altogether,
It
isn't
is
it?
a different issue, yes, this parking that's being taken out.
Can I say something here?
Yes.
I think that the past 2 times when the drive-throughs have come up, there hasn't been enough research by the planning board, and so our not making positive statements on it may have not been as, you know, firmly based as we might. And so I like the idea that if we end up having a forum on this and we can gather data, and to my way of thinking, I am worried about the small restaurants which are doing business who, you know, my son goes and gets a Huck's Hoagie on a regular basis, you know, so I want to support those organizations. But I think we need to get some data so that when this thing comes up the next year, planning board can make a decision based on what we have heard, what we have learned, and therefore make it a better educated decision on whether it should be moved forward.
Seconded.
Yeah,
Agreed.
okay. All right, so basically, what we're back to what we had previously decided, to to have a forum. And,
Yes, you're right.
And I agree, Mike, I think it's not going to be, we're not talking an elaborate study.
No.
We're just talking about getting some ideas down. You'll find out about traffic and information. Tavis can help us with that, and have some facts when we go to the public forum, so that we'll be
I
able
would be
to
happy to
address
help
issues.
do some homework on that. Happy to help.
Okay, so I'm going to,
Did you hear what she said? She wanted to help you
yeah,
on that, yeah?
yes, I heard that.
Okay.
Thank you. All right. Okay, I'll send Mr. Zimmerman an email, and I'll copy all of you so that everybody's in the loop. Okay, minutes, November 17th. Anybody have any issues?
Yeah, page 7.
Okay,
Bottom of page 6 and the top of page 7 regarding EDC on drive-through restaurants. There was, Tavis mentioned he was going to be meeting with EDC chairperson and would advise him the planning board is looking into drive-through restaurants and would be reaching out to the EDC as discussions progressed. Mike Hodder suggested planning board hold off on such. What decision has been taken on that?
I honored the board's direction and have had no conversation with EDC on that matter.
Okay, thank you. That's all I have, Madam Chair.
okay, so no changes. Okay, I'd entertain a motion to approve the...
So moved.
Oh, I'm sorry, John.
Seconded.
said
Okay, you
motion.
guys
You
have
said
made the
moved.
motions, all right, I thought you had some changes.
Come on, Kathy, you gotta catch up here.
Okay, motion has been made and seconded to approve the November 17th minutes. Roll call vote, Peter Goodwin,
Yes.
Brad Harriman,
Yes.
and Von Dugan,
Yes,
Susan Replier,
Yes.
Mike Hodder,
Yes,
John Thurston.
Yes.
Okay, and Kathy Barnard, I vote in favor. All right, the December 1st minutes. Anyone have any changes to those minutes?
no issues here.
Would somebody like to make a motion?
So moved.
Okay, thank you. Motion has been made, I'll second it. Peter Goodwin, roll call vote in favor of the December 1st minutes. That was a yes?
Yes.
Okay. Brad Harriman
Yes.
and Von Dugan,
yes,
Susan Replier,
Yes.
Mike Hodder,
Yes,
John Thurston,
Yes.
and Kathy Barnard. I vote in favor of the December 1st minutes. Information item. Tavis, do you have some items for us?
I actually don't, Madam Chairman. No application has been submitted, so I'll be speaking with you on how you'd like to proceed into January at a later date.
Okay, all right, so any other issues? What about the New Hampshire Boat Museum went to ZBA? Will that be coming to us soon?
I have not heard from them on their expectations for moving forward, but they have 2 years now with the special exception.
Okay. All right. Okay, the next meeting on January 5th, we don't have any public hearings, right?
Correct.
Oh, okay. So impact fees. I sent that information to all of you, and we'll have a discussion about that, plus other items. We'll get started on the 2021 work plan, and we're going to add dwelling units. To
So
that
we're
work.
not discussing impact fee tonight? We're not?
No,
No.
I figured it was a little too complicated.
Okay.
Did anybody have any questions about it?
Well, I read it pretty good there, and I mean, all the meat is at the end, basically when he does his fact finding, but the way I see it, the moral of the story was that the impact fee is based on the pupil capacity from the town to the school district, and when the capacity is reducing down, then we should be scaling our requests accordingly in that impact fee. That was at the end, according, and when people build smaller units, we should adjust that impact fee based on those smaller units, because those aren't producing pupils going to the school district. I mean, so those were my takeaways.
Okay, well, if everybody will sort of focus on that issue so we can kind of figure out in what direction we want to go then. And then on the second meeting, we're going to get started on the master plan implementation. Susan's been working on that, so.
Do you have a date for that?
That's on the 19th of January.
Okay, thank you.
Is there going to be a hearing related to the heights of the Wolfeboro hills and mountains?
Yes, we are, yeah, yes, I've got to talk to Tavis about that. An amendment to the natural resources chapter, right?
Right, and the background of this is that when the Whiteface Mountain property was given with an easement to the Lakes Region Conservation Trust, it was stated that it was the highest mountain or highest point in Wolfeboro, and that is not the case. And so there's all sorts of controversy that's come down from all sorts of places that are important. At the same time, the planning board has lots of other issues that are perhaps more important than the heights of mountains.
Okay. All right.
Thank you.
Anything else, folks? Okay, we can adjourn.
So moved.
Nice holiday season, everyone.
Same to you,
Merry
everyone.
Christmas, everybody.
Oh,
Yes.
yes, roll call. Sorry. Motion to adjourn has been made.
Seconded.
And seconded. Peter Goodwin,
Yes.
Brad Harriman.
Yes, and happy holidays to everybody.
Okay.
Thank you, Brad.
Von Dugan,
Yes.
Susan Ricklier,
Yes.
Mike Potter,
Yes.
and John Thurston.
Yes.
Kathy Barnard, I vote yes. All right.
Merry Christmas, all.
Off you go.